Hello everyone, so this is the first trial of your content being played via a presentation that you should be able to access outside of the lesson. So what I wanted to do was to start with a new topic of occupiers liability. So have a look at the title slide for this and you'll see the learning objectives underneath the title. So occupiers liability essentially refers to actions where occupiers of land are alleged to be responsible for injuries to either visitors or trespassers that have been on their property at a particular time. So in terms of visitors, we would be thinking about those people who have some kind of permission to be on the property. In terms of trespassers, as you'll be aware already, these would be people who do not have permission to be on the land property. So there are two areas that come under occupiers liability. So the first area that we'll be looking at in this presentation will be that governing visitors, so injury or harm caused to visitors whilst on occupiers' land. If you look at the top learning objective, this area of law comes under Occupiers Liability Act 1957. So what we need to do is to describe and apply the rules from this act. So I'm going to get started and hopefully this will go quite smoothly. So turning to the next slide, the general rule is that occupiers of premises owe a reasonable duty of care to visitors and, of course, as I mentioned before, trespassers who are injured on the occupier's property or land. So I've put a couple of things in bold there, and that's because they are the key elements of this area that we need to know about. So underneath you see that I've asked the questions, who is an occupier? So who in law do we class as an occupier? What is meant by premises? Also, what is the duty of care? What do we mean by a reasonable duty? And if you cast your mind back to our negligence lessons, you might have an idea of this already. And who would constitute a lawful visitor? And we also, of course, need to understand the difference between a visitor and a trespasser, because in any potential exam scenario, the question may not be clear as to whether it covers the act for visitors or the act for trespassers. So you need to be able to spot whether the person who would be giving rise to the action would be a visitor or a trespasser. And in most cases it should be quite obvious, and the question would normally give you that information. Moving on then to the first element. So I should start by saying we are, for the purposes of visitors, focusing on the Occupiers Liability Act 1957. So just note that there is a later act that governs trespassers, and that's 1984, and we'll talk a bit about that in the next session. So the 1957 Act is the important act here, and I do make reference to it throughout the slides, so just be aware that is the act. So in determining who is an occupier, and this is the person who would be held responsible, so the owner of the land whereby the accident, the potential negligence has happened, this is the person who is going to be sued by the visitor. So an occupier generally is going to be an owner or a tenant of the premises, but actually the Act provides something much wider than this. This talks about somebody who is in control of the premises, and there's a key case for authority in this regard, and this is underneath in the red box, Wheat and Lacon & Co. Limited, 1966. So if you look at the facts of this case, the manager of a pub was given the right to rent out rooms in his private quarters even though he had no ownership rights. A paying guest fell on an unlit staircase and died. So the House of Lords, as it was called then, decided that both the manager and his employers could be occupiers, since both had control. And that's the key here. And if we relate to other topics, if you think about the law of theft, when we're looking at property belonging to another, it's not just about that proprietary owner, it's also about a person who has control of that property at the time as well. So this is a very similar test. Who is in control at the time? It may not be an owner, for example with a hotel, it may be a manager or a porter or someone. So it's key in the scenario to firstly identify who the occupier is. And I hope that's clear. The next element is premises. So this is actually defined, a premises is actually defined under the Act. So you see here I've put section 1, subsection 3, subsection A. So the Act states any person having occupation or control of any, and this is the important part to highlight, fixed or movable structure, including any vessel, vehicle or aircraft. Now, if you look in your textbooks, you'll see there's a bit more information about premises, and this could, I mean, typically it's going to include structures like houses, offices, buildings, land, ships, vehicles, maybe even smaller premises like lifts, if there's a specific lift in control. And I believe there's reference in the textbook to a ladder, which is quite interesting to think of a ladder as premises. But generally, again, it's going to be quite a straightforward judgment of what is the premises here. Okay. Moving on, who then is a lawful visitor? So who by law is classed as a visitor? So my top point makes reference to a number of different categories. So we have invitees, licensees, those with contractual permission, and those with a statutory right of entry. So let's think about what those mean, and underneath I've given you some explanation of these terms. So an invitee, a person who has been invited, makes sense, and has express permission to be there. So for example, a friend coming round to your house, or delivery workers, perhaps you've asked for an item to be delivered. That would come under the category of an invitee. A licensee may be those who have express or implied permission to be on the land for a particular period. So again, this may actually overlap with invitee. Some of these categories will overlap. We're thinking about here customers maybe in a shop. They would have implied permission by the shop being open. So try and think about the sorts of other people that would come under licensees. But as I say, the categories can overlap. Contractual permission, so anybody who has bought an entry ticket for an event, so something by nature of a contract. This could also mean employees. Contractually, I have permission to be in the school, for example. And statutory right of entry, so remember the term statutory, we're talking about a right by law. So meter readers, those reading utility meters, electricity, gas, etc., water, they will have permission by law to enter a property to read. Police officers will have a right if they are exercising a warrant. Nowadays, if they want to enter property, they do need permission first. Usually they obtain that from the magistrates, if you remember us talking about that at the beginning of year 12. Leads me on to the next slide, which is your first task, and this is something I want you to do. So I'd like you to pause this lecture and actually have a go at this task, and we will go through it in class. So you've got several people here, numbers 1 to 7. I want you to identify which category they come under, and it's okay if you think they may come under 1 or 2, maybe even 3. That's okay if you just write next to them which category you think that they support in terms of visitor. And what we're going to do now, move on to the common duty of care. So once we establish who our 2 main parties for the purpose of an action are, so we have our visitor versus our occupier in a civil action, what are we saying that the occupier owes to that visitor? So if you invite your friend over for dinner or for a drink, what by law do you owe them when they come onto your premises? So this is governed under section 2 subsection 2, and hopefully you remember the act that you could write next to this. And what the common duty is that occupiers do not have to make the visitor completely safe on the premises, only to do what is reasonable. So think about this concept of reasonableness. We've talked about it a lot in law. How would a court decide what is reasonable? And perhaps just make a few notes there and pause this if you need to. The concept of reasonableness, if we think about how do we usually judge that, who are we comparing against? So there is a useful case that you can cite here in your legal authority before you decide on the facts in a scenario whether the duty has been carried out reasonably or not. So this case is Laverton against Kaya Pasha Takeaway Supreme 2002. You would get marks for just stating Laverton or Kaya Pasha Takeaway if you wanted to. So the facts are the defendants owned a small takeaway shop. They had fitted slip-resistant tiles and mopped the floor after it had been raining. When the claimant went into the shop, being Laverton, it was very busy and had been raining. She slipped and broke her ankle. So think about, in this case, who are the occupiers, or who is the occupier, and who here is the visitor, and what type of visitor would Laverton have been. The Court of Appeal in this case decided the shop owners had taken reasonable care to ensure their customers were safe, so they were not liable. So the fact that they had fitted slip-resistant tiles and mopped the floor, what more could they have done? And this is the key question really here. The courts are not expecting you to do everything in your power or everything that they could think of to make a visitor safe. It is based on reasonableness. And if you think back to our breach lessons in negligence, what is reasonable? We're thinking about factors here: the seriousness of the risk, the size, the probability, the cost and the benefits. So think about those factors and link those in if you want, if it helps you to apply to the facts most effectively. So it's important to note here that in terms of this reasonable duty of care, there are 2 situations where this duty of care may not, or it may vary, should I say, it may vary. And that applies to 2 different types of visitors: children and professionals. So the duty, this reasonable duty of care owed by occupiers, may actually vary. So the first talk about is in terms of how it applies to children. So if you have a child who is invited onto your premises, should the duty remain the same to that child? And actually the Act provides for this. And under section 2 subsection 3A of this Act, so note that I'm working in chronological order here. I'm going through the sections in order. It should hopefully help you to remember them when you're writing them out. This Act, or this section, says that occupiers must be prepared for children to be less careful than adults. So the premises, and this is the important thing, must be reasonably safe for a child of that age. So please highlight or underline reasonably safe for a child of that age. So this is interesting here. The Act is actually imposing a higher duty on occupiers where children are concerned. So applying this law, what do you think the outcome is in each of the cases here? So we've got Glasgow Corporation against Taylor, and then Phipps against Rochester Corporation. So ultimately we have a family with a young child who have brought an action against a corporation in terms of negligence under occupiers liability. So they are claiming that an occupier of premises has been negligent and therefore resulted in injury or death of the child. And of course it's for the courts to decide. There may be a duty here if that child is a visitor, but have they breached the duty of care that they owe? So can you read the facts and then decide what was the outcome do you believe? And then what we will do is we will talk about this more in class if you would like to do so. So can you pause it here, and then once you unpause it I will tell you what the outcome is. So hopefully you've paused and had a look at that. So the Glasgow Corporation, the corporation was actually liable. So the court held that the berries were alluring to children, and therefore they should have taken more care to fence them off or cut them down. And the fact that they were aware of that danger would have obviously added, in terms of the facts, to the strength of Taylor's case. And Phipps, in that case, the corporation were not liable. And what they recognised here was that, yes, there was a trench, so there was a dip in the ground that wasn't necessarily safe. However, you would expect a 5-year-old and a 7-year-old to be supervised by their children, and the court here actually recognised that the council can't do everything. They need to be or there needs to be an assumption that children would actually be watched by parents too. And I guess if we are evaluating these decisions, we might argue that that could have been the same outcome in Taylor. We might wonder why in one case there was success and in another case there wasn't. And that's the beauty of law, I guess. So what I want you to think about in terms of further evaluation, why are children owed more care than adult visitors? And if you can write a few notes about this, when we come to evaluating this area in more detail, I'll be wanting to hear from you. Hopefully you're thinking along the lines of obviously children being less aware of danger. So therefore we as adults need to be, and occupiers, we have a responsibility. And if you think about the relevant other areas of law like health and safety, etc., we have that duty to keep people safe generally anyway, and for children it would obviously be far more important, given that we have to safeguard them being more vulnerable than adults. So moving on and just kind of summarising, a duty of care is owed to adults providing they are lawful visitors. Obviously if they are unlawful visitors, they may then be governed by the trespasser legislation, and also a duty of care is owed to children, again providing they are lawful, and we will look in due course at what the case is if they are trespassers. So my next question, I'm going to get a bit more tricky now. What happens where an injury or damage occurs and it is the negligence of somebody else rather than the occupier? What is the relationship, I'm asking, in terms of between occupiers, independent contractors and visitors? Or independent contractors as visitors, and also what is the relationship in terms of tradesmen? So we're going to go through this in a minute. What I just want to make sure you're clear of is the difference between these two types of professionals. So these are professionals. This is the second variant I talked to you about a few slides ago in terms of the variation of the duty of care. So an independent contractor, if you want to make some notes on this, is a third party. So essentially they could be employed by the occupier, but usually they would be employed by somebody else to provide services under an agreement. So this might be something like a building contractor. So for example, at our school we will soon be having building works. So we're refurbishing some of the buildings. We're going to have a new sixth form centre. We have employed a company who are drawing plans and talking to us about the scope of works for that. And what will happen then is, under that agreement, a building firm will be contracted to carry that work out. That building firm is an independent contractor. So they will be linked to us as the occupiers of the land, but ultimately they are a third party, if you like. So what's the situation going to be if they become injured on the land at school, or if, say, one of our students becomes injured through something that they do? Are we still going to be liable? So what you might actually want to do is draw a bit of a diagram where you have occupiers, and you could label Van Dyke School as one of those parties. Draw a line across to visitor, so in this situation it could be student, and then in the middle what you've got is a potential break in that relationship where you might want to write independent contractor. What happens if there is an additional party involved? And then also tradespeople. What happens if they come onto our premises and do work? And what happens if they are injured? Are we liable? Because surely you would expect a professional to take care in what they're doing and to understand the risks of their job. If it's something totally separate, then of course that's a different issue and we would consider liability in the usual way. But if they come onto premises and carry out work directly as tradespeople do, so for example electricians or plumbers, you might want to write that example, then what happens if they are injured? Is it their own fault, and does that therefore, I guess we could say, break the chain? So we need to look at that and consider that now. So we're going to look at tradesmen first, and I'm on to the next slide. So are occupiers liable for the torts of tradesmen? So have a look at this case here, top right, Rolls and Nathan. 2 chimney sweepers died after inhaling carbon monoxide fumes while cleaning the chimney of a coke-fired boiler. The sweeps had been warned of the danger by the owners and told to turn it off. The occupiers were not liable, as they could have expected the chimney sweepers to be aware of the particular danger. So just having a think about why that decision was made. Surely chimney sweepers would be aware of this danger. So therefore, why should you hold occupiers liable? If we go back to the common duty of care, the reasonableness, certainly when you're dealing with a professional, you're going to expect them to be aware of risks related to their area of work. So under section 2, subsection 3b, occupiers do owe tradesmen coming onto the premises the common duty of care. However, they will not be liable where tradesmen fail to guard against risks which they should know about or be expected to know about. So this is a type of defence in a way, and if you see, I've put this in green, and this defence will only work where, as I said before, the tradesman is injured by something related to the actual work being carried out. If a tradesman comes onto Van Dyke premises for the purposes of cleaning or unblocking a sink in a kitchen, but they're actually injured by a big piece of equipment falling onto them, let's say a projector, then that's not going to be related. So therefore we would more likely, as the occupier, be held responsible for that. And whilst we're on the subject of defences, it would be useful to note that the defences we've looked at previously, contributory negligence and consent, or otherwise known as valenti in tort, are also applicable. So we could potentially, as occupiers, argue that somebody has contributed to their injuries, or somebody has fully and willingly consented to their injuries or the harm or the damage. So take a few minutes, pause this and take a few minutes just to summarise those defences before you move on. So there are further defences that are specific to this area of law that you should know about. And I am going to come to the independent contractor situation in a minute, because that can be deemed as a defence. But one really important defence under the Act is that of a warning notice. So you've probably seen these around, occupiers of land do not hold any responsibility, or are not responsible for anybody who walks onto their land, or who injures themselves in a car park, or who has anything stolen out of their car in a car park. These are all warnings, or as we will look at later in contract law, clauses which exclude or limit liability for that occupier. So you're saying, I take no responsibility for what happens to you on this land in this situation. And actually, can that always detract from liability or negate liability? It can't. But a warning notice can limit an occupier's duty. It just depends on how effective that warning is. So under the 1957 Act, Section 2, subsection 4A, what the law says is that a warning is ineffective unless, in all the circumstances, it was enough to enable the visitor to be reasonably safe. So the courts again will be looking at all of the circumstances surrounding the injury, the accident, whatever happened, and was the warning effective? And as an exam link here, examiners like scenarios with this sort of question in. So there have been questions, and we will look at some in class, as to whether, if you're in a hotel and you walk through a door which says private and then you injure yourself, are you going to be able to sue? Does the occupier still have a duty? Are you still a visitor in that case? If you walk into a room which says private, does that then make you a trespasser? And then we move to the other act. So lots of questions to arise out of that type of scenario, which is why it's a common exam theme. So have a look at a couple of cases here. So we've got Ray and Mars, UK, and you could probably find a bit more information about this case online if you wanted to write some more facts. So this involved a drop inside an unlit storeroom, and a person who was walking in here, I believe they were a surveyor, they dropped down and injured their leg. So a warning was insufficient here because it couldn't be seen. And of course you could ask the question, why did they not have a torch, etc. But there should have been more of a warning, or a light on if possible. And then we've got another case here, different facts, Staples against West Dorset District Council. So the claimant fractured his hip when he slipped and fell off a harbour wall. The harbour wall was a well-known tourist attraction. The edge was covered with algae and extremely slippery when wet. The claimant had crouched in the area affected by the algae to take a photo of his friends when he slipped and fell off a 20-foot drop, landing on rocks below. So an action was brought arguing that no warning signs were present as to the danger. But actually, because this was such a well-known tourist attraction, this claimant should have been aware of the danger. And if we think back to the common duty of care, common sense would dictate that this would be a dangerous thing to do. So therefore, the council was not liable in this case. The warning can be written or oral, but of course, if it's oral, it's going to be more difficult to evidence that in court. And we know with civil cases, this is very much a 50-50 type swaying. This isn't a beyond all reasonable doubt type case, so written evidence will help to push the balance over the edge, if you like. And of course, warnings, if they're clear, if you look top right, if they're colourful, if they're clear, they're going to be more effective. And we get to the passing liability onto third parties or independent contractors. So let's look at the law first. So this could be a potential defence for an occupier if a visitor is injured by negligent work. So let's say our building contractors build our new sixth form centre, but it ends up crumbling, God forbid, and injures students. Can we then pass any claims for negligence onto that building firm? That's the question, isn't it? So we may be able to pass that liability on under section 2 subsection 4b, but there are 3 conditions. So firstly, it must have been reasonable for the occupier to have given the work to the contractor. So if you think in the case of the Van Dyke building renovation scenario, of course it would be reasonable for us to give the work to a contractor. The person hired must be competent to carry out the work. So we need to do some due diligence, so carrying out some background checks into this building firm. Are they reputable? Have we seen examples of their work? We actually had a tendering process for building firms, so I'm sure that would have been carried out. And even if you're having some low-level building works done on your home, you know, kitchen extension or new bathroom, it would be reasonable to expect us to find a bit out about the builder so that we know that they're competent. So that's quite a valid question, I think. Thirdly, the occupier must check that the work has been properly done. And obviously this can be a bit tricky if you don't have expertise in that area, and the court will of course take this into account. But usually with building works you'd need to get them signed off, so building control departments at the council, a building inspector will need to come out and sign it off and validate it. So that type of sign off can then release an occupier of their liability if anything happens as a result later. Okay, so this is about passing liability on. So now something for you to do, I want you to have a look at the 3 cases on the right on the slide, starting with Hazeldine and Dorr and Son, and establish whether you or who you believe is responsible. Do you believe the occupier in the situation is responsible for the visitor's injury, or do you believe the independent contractor would be responsible instead? So I want you to read those, please. Pause this and then make a note, and then I will go through it in a second. So assuming you've done what I've asked, Hazeldine and Dorr and Son, here the occupier was not liable, and that's because ultimately, hopefully you've recognised that the work had been given to a specialist firm, and therefore it would have been quite difficult under number 3, the requirement 3, for the occupier to check that the work has been properly done. Secondly, Woodward. So the local authority was liable. They failed to check the work had been carried out properly, so they actually failed on requirement 3. It's quite easy, you don't need to be a specialist to check whether school steps are icy, so it's quite reasonable to find the occupier responsible. And then thirdly, with Bottomley, the cricket club was liable because they failed to choose safe and competent contractors. What happened here, which you might not know without doing more reading of this case, was that the stunt team actually had no insurance as well, so that you might deem or glean from the facts that they weren't going to be competent. So I hope that that helps you in terms of identifying potential defences here for occupiers. And what we've got here finally, potential defence, use of exclusion clauses that I mentioned before. We will look at these more under contract law, but section 2(1) of the Act says that an occupier can, or they're able to restrict, modify or exclude their duty by agreement or otherwise. So obviously restrict meaning limit, modify meaning amending, exclude completely removing their duty. This is only for residential occupiers. So interestingly, you may have seen signs like the ones displayed, but if they are displayed by a tradesman or an independent contractor, they're not going to certainly exclude the duty. They may be taken into account, but it's not going to, by the Act, give them a full proof defence. It may work against children, but obviously it depends on the child whether they can understand. A 5-year-old may not understand that type of sign or that warning, for example. So I just want you to think about, before you move on, whether the sign above would be valid.